Hello and welcome, everyone. Thank you so much for joining us today. We're going to give it just another minute till everyone hop on and get settled before we get started. Hello and welcome to those of you just joining us. We're going to give it just another minute, let everyone get logged on and settled before we start today's presentation. All right, it looks like the bulk of the people who have registered to join us today are here, so we can go ahead and get started. Hello, my name is Kelsey. I'm the marketing coordinator here at Jarvis Law Office. Thank you again for joining us today. Just a couple of housekeeping things before we do get started. During the presentation, we would love for you to ask questions, or if you're experiencing any technical difficulties, we'd love to help you with that too. You can send us a message using the chat feature. If you're on your desktop or your laptop, it's likely on the right-hand side of the screen. You'll see a little box where you can type in a message. If you're on mobile, you might have to scroll down underneath the video, and it should be right underneath. The messages are private. The only people that will be able to see it are myself, Attorney Jarvis, and my partner, Stephanie, who's on helping me today. And with that, I'm going to go ahead and introduce our presenter, our founder and president, Attorney Tim Jarvis.
Great. Thanks so much, Kelsey. And I want to thank each of you for joining us today. I hope this is a good use of your time. If you're not experiencing any technical difficulties, what you should be seeing on your screen, the title of today's presentation, How to Avoid Going Broke in the Nursing Home, alternatively known as Medicaid 101. So if you can see that on your screen and you can hear me okay, then I would guess all is good. If you can't see that on your screen, if you just type something to that effect into the chat box, and either Kelsey or Stephanie will reach out and help troubleshoot whatever issues you're experiencing. But without any further ado, I'm going to go ahead and jump into the presentation. So what we're going to be talking about today, what you'll discover, is how to avoid probate. And just as importantly, we'll talk about why it's such a big deal that you do have your affairs set up so that everything bypasses this probate process. We're going to talk about some of the elder law power tools that really need to be a part of your plan. And then we'll finish up by talking about one of the biggest risks out there. In fact, in my mind, it's the single biggest financial risk any of us will face during the rest of our lifetimes. And that's the risk of needing long-term care. So how to protect yourself and your family in the event that type of care is needed. So we'll be talking about each of these things throughout the presentation. And again, as you have questions, we will have time for a Q&A session at the end. But as we go through the material, if a question pops up, just go ahead and type it into the chat box so you don't forget to ask it later. All right, so who is this presentation for? Well, if you're sick and tired of worrying about protecting yourself, your loved one, your family, you're confused about all the conflicting advice that's out there, it seems like you could ask anyone how to best plan for these types of issues, and they'll all tell you. Unfortunately, most of that information is not correct. So we'll kind of talk about the way that you do want to plan these issues. We'll talk about the straight talk as far as what you really need to be doing now so you can finally stop worrying about all of these issues becoming a problem for you and your family at some point down the road. All right, so now ask you all a question. What if you could just wave that magic wand and guarantee that you have a clear plan for your future where your spouse or your kids aren't forced to try to figure out how to clean up a mess, whether it be from probate or the long-term care scenario. How can you make sure that you have enough income and assets to last you the rest of your life? And if you're married, how can you make sure that your spouse has enough money to last them the rest of their lifetime. If you could have a plan for care so you never have to worry about being a burden on your spouse or your kids or other family members, where you don't have to worry about losing what you've worked your whole life for, and how can you protect whatever the ultimate inheritance is that you leave to your kids or other beneficiaries, where no one can ever take that money away from them. And how do we also build a plan to really minimize the possibility that any of the family is going to be, fighting over who gets what, which often comes into play if someone doesn't have their affairs planned out the way they should. So if you could wave that magic wand and guarantee that you get the end result that you're hoping for, I don't think any of us would spend much time wondering whether we should wave that wand or not. I think we would all do it in a heartbeat. Well, obviously, it's not that easy. However, it's not overly complicated either. Really, the most important thing with all of this is just making the commitment that you're going to get this area of your life taken care of. You're not going to continue to think about it indefinitely. As we all know, tomorrow's not promised to any of us, and none of us come with an expiration date. And so if we knew exactly, when we were going to leave this world, or we knew exactly if and when we ever needed long-term care, this would be a whole lot easier. But obviously, none of us have that luxury. And so putting this off until you think it's closer to the time when it's actually going to be needed, that's a recipe for disaster. Because so many of the families we sit down with, it is with the adult children or with the spouse who's trying to figure out how to address these issues while they're in the midst of it. And I can tell you that is absolutely not the best time to be trying to address these various issues. All right, so just a little bit of background as far as who I am. Here's a picture of me and my now fiance, the evening that we were engaged. Now, my fiance, the reason I'm showing you a picture of her as well is she's actually my practice manager. So she's the one who runs the practice. And like I said, this is a picture taken when we were engaged. She was my very first employee, and I don't even refer to her as an employee any longer, but and we actually started dating before she came to work for me. So I know what you're thinking, that I poached one of my employees, and that's absolutely not the case. Now, I've lost a little bit of weight since then. Hopefully that's kind of apparent. Was down close to about 50 pounds prior to the holidays. Unfortunately, just like probably everyone else, I gained a couple of pounds back, but feel a whole lot better. So I never wanted to be an attorney growing up. In fact, the thought never even really crossed my mind. My folks didn't have any friends who were attorneys, and fortunately, I never had the occasion to have to work with an attorney myself. And all the things I had ever heard about attorneys, quite frankly, not very positive. So no desire to go to law school when I was growing up. What happened that kind of changed my path is my grandmother, who I was incredibly close with. As a kid, I used to spend summers with her. She was almost like a second mother to me. But she started to have some health issues. More specifically, she was diagnosed with Alzheimer's. So my original career, because like I said, I had no plan to be an attorney. My original career was a financial advisor. So I was a licensed stockbroker. I'm still a certified financial planner. Did that for about the first 10 or 12 years of my career. When my grandmother received that diagnosis of the Alzheimer's, my family tapped me and said, all right, Tim, you're the financial guy. You need to figure out what we should be doing in the event her Alzheimer's causes her to need nursing home care. So when my family told me that was my job to figure it out, at the time I thought, sure, no problem. I'll do the research. I'll talk to the various professionals, and we'll get this thing figured out pretty quickly. Well, that's not at all the way it turned out. After about 2 years of trying to figure out this whole long-term care maze, still had no idea what we should be doing with her planning. And I sat down with at least half a dozen attorneys. Now, most of them were estate planning attorneys. But back then, I didn't know the difference. I kind of just assumed that one attorney does the same thing as every other attorney. And if any attorney could help me, then every attorney should be able to help me. And unfortunately, that's absolutely not the way it works. And each attorney I sat down with would start our conversation by saying something like, well, Tim, this is not really what we do here. Not 100% sure how all of this works. Basically, they were telling me they didn't know any more about this than I did. It was incredibly frustrating. Not to mention the fact that didn't stop them from billing me $500 to $700, even though they couldn't answer any of my questions. I had all but given up. And then one of my friends suggested I go see an attorney that he was familiar with. And he said, I think this guy's practice is different. I think he can help you with your grandmother's scenario. Long story, a little bit less long. He was one of the very first elder law attorneys. And he sat me down and just explained everything, start to finish. And there was no doubt in my mind that he knew exactly what he was talking about. So much so that it just felt like the weight of the world was being lifted off my shoulders, because now I knew what the plan was. Now, I had no idea what kind of care she would ultimately need, but I knew that regardless, there was a plan in place to allow her to get the best care available, but in a way that she didn't have to worry about how long she could afford to pay for that care. So we did hire the attorney. He put a plan in place for her. And despite my family's best efforts at keeping her in her own home, there came a time where we just couldn't do it any longer, and make sure that she was safe. So we did have to transition her to a nursing home. And physically, she was very healthy up until the very end. Mentally, not so much. After about 2 years of being in the nursing home, she didn't know who she was, let alone any of the family. In fact, I'll never forget that the first time she looked at me square in the eye, had no idea who I was. In fact, if I think too long about it, I'll get choked up, even to this day. So if you're going through a situation like that, my heart goes out to you. I know how impossible that type of situation is. But back to her situation, because her physical health was so good, she lived in the nursing home for about 10 years before she passed away. And when she did pass away, she had about the same amount of money at that point as she did when she first went into the nursing home. And that's all thanks to that plan that attorney had put in place for her. So going through that process and just feeling completely overwhelmed and not knowing where to turn to for help and almost giving up, and then seeing what this attorney was able to do, not just for my grandmother, but my entire family. The worry and stress and anxiety that he was able to take off of our plates completely. That's what made me decide that I wanted to help other families who are going through the same sort of situation. So I went to law school specifically so I could practice in the area of elder law. So in my firm today, we only practice in two areas. We do elder law and we do estate planning, which in my mind are kind of two sides of the same coin. However, most estate planning law firms don't do elder law. And I think once we go through the material today, hopefully it'll become abundantly clear why you want to work with someone who practices in this area of the law. All right, so here's a picture of the other people who are most important to me in my life. This is a picture of my three kids. It's Ashley on the left, Emily in the middle, and Joseph on the right. When I put this presentation together, I couldn't believe that this was the most recent picture I have of all three kids together. This was taken about 2 years ago. But if any of you have kids, you probably know what it's like. It feels like herding cats just to get the three of them in the same place at the same time, where they can sit still for more than about 30 seconds. So I guess I have to plan something to update this picture. So why am I so passionate about this area? This type of practice? Well, it's because I've been there with my grandmother. And I know how overwhelming this can all feel. And like I said, I researched this for about 2 years before I finally found that attorney who could help me with this. So the deck is not stacked in our favor. Government makes the rules, the deck is stacked in their favor. However, there are things that legally you can do so that you don't run the risk of losing everything. All right. I'm going to share with you one case example, for lack of a better term. This is Kathy. That's a picture of Kathy, my client. One of the things that I absolutely love about working in this area of the law is our clients oftentimes get to feel almost like our extended family. And that's definitely the case with Kathy. And obviously she gave us her permission to share her story. She actually recorded a very touching, very powerful video. I'm not going to show the video to you today, only because every time I watch it, I get choked up a little bit. Kathy shares a little bit about her experience with her husband, who was diagnosed with dementia, what she thought the end result might look like, and then what it meant to have my firm guide her through this process. So we'll send you all a link. We'll email you a link to the video of Kathy. Like I said, I just can't show it now because I'll get teared up a little bit. But as I mentioned, Kathy's husband had dementia. And Kathy actually worked in another law firm. And so when his dementia got to the point where she knew that she wasn't going to be able to give him the type of care that he needed in their home, she was still working. She talked to the attorneys in her firm and asked them what she could be doing to try to preserve some of the assets from being lost to the nursing home. And they said, well, Kathy, with this kind of planning, there's a 5-year look back period. If you don't think your husband has 5 years before he's going to go into a nursing home, unfortunately, it's too late. Now, fortunately, they said, you know what? We don't specialize in this area of the law. You probably want to talk to someone who does. So as luck would have it, one of our office locations is directly across the street from the firm that Kathy works in. So she contacted us and we got together. And again, she didn't think there was really anything we're going to be able to do. Fortunately, we were able to put a plan in place that preserved the vast majority of their assets, despite the fact that he did need nursing home care. So again, if you're interested in what Kathy's experience was, what she has to say about it, we'll send you the link to the video. And, I would encourage you to take a look. All right. So how can you protect yourself, your family, while at the same time maintaining control over everything, where we can save time and quite a bit of money as well? And what we'll talk about with these various issues, kind of what the consequences are if you don't address them appropriately ahead of time. So again, what we're going to talk about is how and why you want to make sure that nothing ever has to go through the probate process. We'll talk about some of the tools that you need to make sure are a part of your plan. And then we'll wrap it up by talking about how to plan and pay for long-term care expenses without running the risk of losing everything. All right, so let's go ahead and jump into this. Probate. Why is this so important that you make sure that everything you have is set up to bypass this process? Well, it comes down to two issues, time and money. So first of all, let me just briefly explain what probate is. I'm assuming all of you have heard about it, but I don't want to make that assumption. So probate, at least the context that we're referring to it, is when someone passes away, if they haven't taken the steps necessary to bypass this process, then this is the court process where the court is going to make sure that, first of all, any and all of your legal debts get paid first. So any of your creditors, they get paid first. And then once the court is satisfied that all of your debts have been paid off, then whatever's left can go to your beneficiaries, whoever they may be. Now, I think we've all been told that we need to have a will. And I think most, if not all of us, have been told that you want to bypass this probate process like the plague. And personally, I agree with that. But over the years, I've sat down with many, many families where they knew they wanted to bypass this probate process. Not all of them were 100% sure why, but they were told that this is a bad thing. Most of those families also thought that they had their affairs set up so that they would bypass probate. And unfortunately, most of them were not set up that way. And the reason I say that is many of us are under the impression that if we have a will, which obviously directs who gets what when we die, many of us think that that in and of itself bypasses the probate process. And a lot of people think that it's only if you don't have a will that you have to go through this probate process. And unfortunately, that's not how it works. Think of your will as the instructions you're leaving to the probate court judge to tell him or her who you want your stuff to go to, meaning who your beneficiaries are, and who you want to put in charge of that process, meaning who your executor is. But again, if the will controls who gets what when you're gone, that by definition is the probate process. Now, again, the main reasons why you don't want to put your family through this, time and money. On average, to get through the probate process from start to finish here in Ohio, we're looking at anywhere from 8 to 12 months. Now, that's not even the worst of it. In my mind, the single biggest reason why you don't want to put your family through this is the cost. AARP did a study to try to determine what is the average cost to get through this process, once you've paid everyone who's involved with this. And this was a national study. And what they determined the average cost was to get through this probate process was anywhere from 5 to 7% of everything you own. And here in Ohio, I would say that's dead on, maybe 5 to 8%, unless your beneficiaries are fighting over who gets what. And if they are, that fee is going to go up very, very quickly. But just for the sake of example, let's assume that the fee is on the low end. Let's say it's 5%. That might not sound like a huge problem to you, but let's do the math. Let's say that when I die, I only have two things that have to go through this probate process. I've got a house and I've got one bank account. And my will says I leave everything to my 3 kids. Well, just so I don't have to find a calculator, I'm going to use easy numbers to work with. Let's say my house is worth $100,000 and in my bank account, there's $100,000 in there as well. So the total value of my probate estate, $200,000. Well, if it takes 5% to handle my estate, 5% of $200,000, that's $10,000. So 10 grand just to get my one house, my one bank account to my 3 kids. Now, I think all of us probably think that that's more than excessive. In my mind, that comes close to highway robbery. And yet, the majority of people, when they pass away in this country, end up going through this process. In fact, I was reading a report a couple months ago that said something like it was over 60% of adults in this country, when they pass away, their estates have to go through probate. Now, I think it's a fair question for us to ask, well, why is that? If this is such a bad process, or at least not a friendly process, and it's so expensive, why do so many of us have to go through this? Well, you'll understand when I tell you that the lion's share of the fee that's involved with this process, that money's not going to the probate court. It's not going to the state. The lion's share of that fee is going to the attorney who's handling the estate. Now, the attorney doesn't get 100% of it, but we get the majority of it. So if the fee was 5%, I would conservatively estimate that the attorney is going to get about 60% of that. So 60% of 5, if I'm doing the math right, is 3%. So if I could get 3% of what each of my clients have, over the course of let's say a 30-year legal career, I mean, that is a fortune. Now, I'm not suggesting that the attorneys who do a lot of this probate work, that they're not earning their keep, so to speak. There's a lot of work that goes into this. My point is, it's all voluntary. You don't have to put your family through this. Now, reason why I want to make sure that you folks understand, first of all, how expensive this is, and secondly, that the majority of that fee is going to the attorney, is I'm willing to guess most, if not all of you, have already worked with at least one attorney. And I'm willing to guess that many of you were told by your attorney something similar that most of my clients were told by their attorney, before they worked with me. And that's where the attorney will tell you that really all you need is a will-based plan. A will, a power of attorney, the healthcare documents, and they'll make it sound like they're looking out for you. Why spend more money than what's absolutely necessary? Well, they're probably not looking out for you. They're looking out for what makes them more money in the long run. And that's setting up each of their clients to have to go through this process. So if the easy way to tell if you're set up to go through this is if in your estate plan, the will controls who gets what when you're gone, then by definition, that means your estate is set up to go through probate. So that's not to say you don't need to have a will. Everyone over 18, in my mind, should have at least a will. We just don't want the will controlling who gets what when you're gone. The will is there, in my mind, to help reduce or eliminate any of the fighting as far as who gets what when you're gone. If we have a will, even though we're never going to submit it to the probate court, that can put an end to this squabbling pretty quickly, because it's written proof as far as who you want your assets to go to when you're gone. Again, we just don't want the will actually controlling who gets what. There are other ways to do that. The last bullet point I've got on the slide, this is one of my absolute favorite statistics to talk about, only because it's somewhat surprising. At least I think you'll probably agree with me that maybe shocking is a better word. But there was a study done by one of the big mutual fund companies, and this was several years ago. And what they were trying to figure out was, on average, how long does an inheritance last? Or to put that in other words, how long does it take the kids to completely spend through their inheritance? This was a multi-year study. They tracked all sizes of accounts. It wasn't just the accounts with $10 or the accounts with 10 million. It was everything across the board, several years. If we were doing this in person, I would ask you to guess how long you think that that number was. How long does it take the kids to spend through their inheritance? And my guess is none of us would get all that close. So I'll just cut to the chase. According to this study, average length of time it takes the kids or whoever your beneficiaries are to completely spend through their inheritance, 73 days. Now, again, if we were doing this in person, I would fully expect that most of your jaws just dropped. I know mine did when I first read this study. And now that I've been practicing for coming up on 18 years, I can tell you firsthand, this problem is not just limited to the younger beneficiaries, the 18-year-olds out there. We've had many, many, many of the adult children of our clients who are in their 40s and 50s. They get their inheritance, from their parents, our clients, and then we see what the kids do with that money. And oftentimes they spend it every bit as quickly as you would expect from an 18-year-old. Now, my point in telling you this, not just because it's kind of an interesting statistic, it's because you can set up your affairs so that your beneficiaries can't blow everything that quickly. So if you're concerned that one or more of them might be likely to do that, you don't have to give them that option. And the rules don't have to be the same for each beneficiary. So if you've got 3 kids and 2 of them are fantastic at managing their money and one not as much, doesn't mean they're not still a fantastic person, just means that's not one of their strong suits. So the rules don't have to be the same for each beneficiary. So again, I would just encourage each of you to spend a little bit of time thinking about whether or not it makes sense to build in any, we call them speed bumps, to slow down the beneficiary spending. Obviously, once that money is gone, there's no getting it back. And we can build in whatever provisions you would want the inheritance to be bound by, for the beneficiaries. All right, so what do you need to do? Well, there are many, many ways to bypass probate. There's things like payable on death, transfer on death, beneficiary designations, owning assets joint with rights of survivorship, many different ways. So we're not going to go through every single option. I mean, it would take more than the time we have left today. my point with this is, if this is a concern of yours, would be more than happy to walk you through how to set up each of your assets so that nothing has to go through this probate process. And by doing that, you're going to keep things simple and easy for your family, your beneficiaries. We can overcome the hurdles of frequently missed items and unfair or uneven amounts passing to your kids or other beneficiaries. And what a lot of my clients have done before they work with us is they'll pick one of the kids and they'll set up everything in survivorship with that child, with the thinking that by doing that, when the parent dies, nothing will have to go through probate, so everything will go to the survivor, which will likely be the child. And if mom or dad is no longer competent at some point, the child can manage the bank accounts and whatnot because they're on the account. Well, the problem is, if you have more than one child, when you pass away and everything goes to the whichever child you named as survivor, there's no guarantee that they're going to split that with their siblings. And you probably wouldn't believe, or maybe you would, the number of times I've had this conversation with my clients, and they'll tell me, well, Tim, I raised my kids right. They're never going to take advantage of that. They're going to do the right thing by their siblings. That's not always what happens. In fact, oftentimes that's not at all what happens. And in my mind, why take that risk? It's pretty darn simple to set things up where you can still bypass probate. If you're no longer competent, whoever you want can step in your shoes and take over for you. But we can make sure that when you pass away, everything goes to the people that you want it to go to. We don't have to rely on one of the beneficiaries doing the right thing. All right. So the next thing we'll talk about is, actually we'll limit it because I know we don't have an indefinite amount of time. We'll limit this to the one supercharged tool that you absolutely need to make sure you've got as part of your plan, and that this tool has the right language in it to allow you to do the things that you may need to do, or your family may need to do on your behalf at some point down the road. Now, when I tell you what the tool is that I'm referring to, my guess is most, if not all of you, are going to think, well, yeah, that's simple, Tim. Why are you even taking our time talking about this? Well, it's because even though I'm assuming you all already have this tool in place, I'd also be willing to bet that it's not strong enough for what it may need to do in the future. So the tool I'm talking about is the financial power of attorney document, also known as a general power of attorney or a general durable power of attorney. This is a document where you're naming at least one other person. You're giving them the authority to manage your affairs on your behalf, so that if for whatever reason you can't manage your own affairs, either something like a stroke or dementia, Alzheimer's, that it's not a big legal issue. Whoever you've named as your power of attorney just steps in your shoes and takes over. And then obviously with each of these positions, power of attorney, executor, trustee, what have you, you want to name your primary decision maker and then at least one backup decision maker. Now, I know that probably sounds like it's obvious. I don't know that you would believe me if I told you that. I wouldn't say over 50%, but probably close there too. The clients I sit down with, husband and wife, husband's named the wife as his power of attorney, wife names husband as her power of attorney. There's no backups named, which means when the first of them passes away, surviving spouse no longer has a power of attorney. Now, if the surviving spouse is still competent, no big deal, as long as he or she gets a new power of attorney in place. But if they're not competent any longer, well, now that's a huge legal issue. Our only choice in that case is to petition the probate court for a guardianship. Now, in my mind, anytime you're in the court system, it means someone screwed up pretty badly somewhere along the line. And nothing against the courts. I mean, they do the best they can, but it's going to be more expensive. It's going to take a whole lot more time, and you may not get the end result you were hoping for. So by having a power of attorney that's powerful enough, we can bypass this process. Now, the power of attorney is the document that we have more problems with than any of the other legal documents combined, and it's not even close. And the scenario that we run into this problem is when, well, I'll just give you a hypothetical. Let's say we've got husband and wife, husband's in the nursing home and he's not coming home. The wife is in our office talking to us about what, if anything, we can do to help make sure that she has enough to last her the rest of her lifetime. Well, one of the very first things I'm going to ask her is, does she have a power of attorney over her husband? Now, if she does, that we're not done. What I have to do next is read through the entire document to see if she's been given the authority to do what we're going to need her to do to legally preserve any of these assets. Now, one of the things I'm referring to is whether or not she has the ability to make gifts of his assets. The reason why that's so important, the very first thing we're going to need to do to preserve any of the assets is whatever's in his name, we have to transfer those assets out of his name. Now, legally, if we're doing that, we're transferring assets out of his name, that's a gift. And the law in Ohio says that whoever your decision maker is, who you've named as your power of attorney, they are not legally allowed to make gifts of your assets unless you've specifically said they can within the power of attorney document. Now, the reason why this is such a big problem, the only time you would need this language, as far as I'm aware, is when we're dealing with the nursing home issue. Most attorneys don't do nursing home planning. As a result, most attorneys don't know that this is an issue. They don't put that language in their power of attorney documents. And without it, we're done. There's not going to be anything we can do in most cases to help legally preserve any of their assets. So this literally comes down to a couple of sentences. If that language is in there, then we can do whatever we need to do to be able to preserve a pretty large portion of their assets, which I'll talk about here in a few moments. If that language is not in there, we're done. All right. Now, that's just one example. That there's another half a dozen other things that we're looking for. Now, rather than go through each item, line by line, and then instruct all of you when we're done to pull out your power of attorney document and start going through it, we'll make it a whole lot easier for you. If you stick around to the end, I'll explain how you can have us review any of your documents, and it's not going to cost you a dime. All right, so stick around to the end, and I'll explain what I'm talking about. All right, so back to my grandmother's situation. She did have a power of attorney document in place, but again, it didn't have that language that I'm referring to. Now, fortunately, even though she had already been diagnosed with dementia, it wasn't too late. She still had enough capacity where she legally could sign a new power of attorney document that did have all the appropriate language in it. Had we waited a little bit longer, or had it taken a little bit longer to find that attorney who could help us, it more than likely would have been too late. There wouldn't have been anything we could do legally to help preserve her assets. Now, this is a picture of my grandmother. She's the one obviously in the middle there in the wheelchair. Now, this was taken at the nursing home, and this was shortly before she passed away. So if some of you have any experience with dementia or Alzheimer's, if you look closely at her face, you can kind of see that maybe she's not 100% herself. I don't know how else to put that diplomatically. But at this point that this picture was taken, she didn't know who any of us were. Now, I still am grateful that my kids, which are on the left side of your screen, those are my three kids when they were much younger, that they got to meet their great-grandmother. So now when I tell them stories of all the hijinks we used to get into when I was a kid in the summertime, they know who I'm talking about. That's my mom behind my grandmother. That's me when I was a little bit younger and stockier, and that's my brother Ben and his three kids on the right side. All right, so I think we've talked about the power of attorney issue enough. I don't know that I need to beat that dead horse any longer. I can't stress enough how important it is that you make sure that you've got the appropriate language in that document. Otherwise, we may not be able to do legally the things that we otherwise could have done to help preserve your assets. So last thing we're going to talk about, as I mentioned at the beginning, in my mind, this is the single biggest financial risk any of us will face in the rest of our lifetimes. And that's, again, the risk of needing long-term care. Now, unless you've been through this with a family member, you may not know how expensive this type of care is. So if we're talking about full-blown nursing home care, most of my clients who are in the nursing home are paying anywhere from $8,000 to $12,000 a month. And we're not even talking about the Ritz-Carltons of nursing homes. And we're just talking about good facilities that provide good care. But they're incredibly expensive. I don't think I've got anyone today paying less than $8,000. I think most of my clients are closer to that higher end of that range than they are to the lower end. So the obvious question becomes, well, at that kind of monthly expense, how long is it going to be before you're out of money? Well, the national average when someone goes in the nursing home, if they're going to be there indefinitely, meaning not a short-term rehab stay, national average is they're completely out of money within 3 years or less. And in fact, about 50% of those folks are completely out of money within about 18 months or less, year and a half. So that's what we're talking about here as far as what this can look like if you don't plan for this ahead of time. All right, so as far as how you preserve your assets from the cost of long-term care, we'll talk about a couple of different options. We'll talk about how Medicaid works. Medicaid is a program that would pay for someone's nursing home care, but you have to qualify for it. So this is a means-tested program, meaning they're going to look at how much money you have, they're going to look at your income, and then they're going to determine how much you have to spend down before you're eligible for Medicaid. Now, don't make the mistake of thinking that Medicare pays for the nursing home long-term. It doesn't. At most, Medicare will pay for up to 100 days of nursing home care. And you're not even guaranteed to get the full 100 days. You have to be making progress in whatever therapies they're providing to you, and you have to be getting better in order for Medicare to continue paying. But even if you are getting better, once you hit the 100-day mark, Medicare's done. And at that point, you either have to start paying out of pocket, you've got long-term care insurance, or you qualify for Medicaid. And the rules for Medicaid are different if you're single versus if you're married. So we're going to start by looking at the rules for a single person. Now, before I get into the spend down rules, what I need to explain is whether you're single or married, there are certain assets that Medicaid doesn't care about. They're called exempt assets. And there are 3 types of exempt assets. This is true whether you're single or married, same 3 types. The first one is you're allowed 1 vehicle regardless of the value. Now that's 1 vehicle total, meaning if you're married, that's not 1 vehicle per spouse, 1 vehicle total. You can prepay for your final expenses, your funeral. If you're married, both of you can do that. And all of the stuff, your household goods, those are all exempt, meaning Medicaid's never going to pull up in front of your home with a moving van to take your furniture, all of your stuff. They don't want that stuff. They do want pretty much everything else. So if it's not one of those 3 exempt assets, then it's considered a countable asset. And the math is really easy if you're single. The most you can have in total countable assets and still get approved for Medicaid, it's $2,000. So you pretty much have to be broke before Medicaid's going to be an option if you're single. Now, the thing to remember is even if you just follow what the Medicaid department is going to tell you, spend all your money on your nursing home care until you've got no more than $2,000 left, then you get on Medicaid. Well, the thing to understand is Medicaid doesn't pay for everything. And so if there's anything you need that Medicaid just doesn't cover, then either your family will be forced to help pay for your care, or even worse, you go without. And that's not something we want to have anyone have to go through. So just makes the importance of planning for this so much more important. And I think it's going to become even more important down the road. With all of the money that the government is been forced to spend to get us through this pandemic, they're going to have to find a way to pay for it. So I'll talk about how the rules may be changing in the not too distant future. Talk about that here in a few moments. So if you're single, again, the most you can have in total countable assets is $2,000. Rules are better if you're married. The biggest difference between being single and being married, as far as Medicaid goes, I'll leave everything else up to your own opinion. But as far as Medicaid goes, the biggest difference is with the home. So if you're married, and as long as one spouse is still living in the home is exempt, meaning Medicaid can't do a thing with it, at least initially. Now, that doesn't mean the home is protected forever. It's not. And if you're single, the home is not exempt for any period of time. It's countable, which means you'd have to sell your home, use all the proceeds you get from that on your care, and then when you're down to $2,000, then Medicaid would be available to you. If you're married, and like I said, as long as one of you is still living in the home is exempt. So if we've got, let's say, a husband and wife, husband's in the nursing home, they spend down whatever they need to, and he gets on Medicaid. The state starts paying his bill. When he dies, whatever amount the state paid for his care, they want that money back. It's called a state recovery. Now, they can't make the wife, in our example, give up any of her money to pay off this debt. Legally, they're not allowed to do that. What they can and what they will do is they'll file a lien against the home for whatever amount they paid for husband's care. They just can't collect on that lien as long as the wife is still living in the home. But when the wife is no longer living in the home, either because she passed away or she needs care outside of the home, when she's no longer living in the home, that's when the state can collect on that lien. Now, believe it or not, the home is one of the easiest things for us to protect when we're working with a married couple. There are certain rules that apply only to the home, only if you're married. Those rules make it where we can almost always save the house. With all of the other assets, if you're married, again, you still get those same 3 exempt assets: one vehicle, prepay your funerals, and all of the household goods. Those are all still exempt. And the house is exempt as well, as long as one of you is still living in there. Everything else is countable. And it doesn't matter whose name is on what account. Everything could be in wife's name, and if husband goes in the nursing home, their Medicaid is still going to count all of the assets as if they're jointly owned, even if they're not. And generally, if only one spouse is needing Medicaid, generally it's a 50-50 split between husband and wife with those countable assets, meaning husband gets half, wife gets half. Whichever one is going into the nursing home, they have to spend down their half down to $2,000. Once they do, they're eligible for Medicaid. Now, that's the good news, the 50-50 split. The bad news is it's not always a 50-50 split. There is a cap or a maximum amount that they're going to let the healthy spouse keep. And this is a federal rule. Doesn't matter what state you're in, the number is the same. And it's not overly generous. Right now, the cap is that figure you see on the slide, $128,640. So don't make the mistake of thinking, well, if I only get to keep half of the assets we have, that'll still be more than enough to last me the rest of my lifetime. The reason why you don't want to think of it that way is if your total assets are more than twice this figure on the screen, so more than $257,000, then you don't get half. You're capped out at the $128,640 number. Everything else would have to be spent down on your spouse's care before they're eligible for Medicaid. All right. So again, this is how the rules work if you're married, and we looked at how they work if you're single. So the key with this is to let the plan do the heavy lifting. I mentioned that Medicaid was a means-tested program. There's also something called the look-back period. And I think you've all probably are familiar with that term. Look-back period is 5 years. Now, what that means is if we implement the appropriate plan and then we get 5 years under our belt before you or your spouse needs long-term care, once we're through that 5 years, we we're done. We can protect every last dime that someone has. Now, even if we don't get through the 5 years, let's say we implement the plan and 6 months later, one of the spouses has a stroke, they're in the nursing home and they're not coming home. Generally speaking, we can save at least 50% of what otherwise would have been lost to the nursing home. And this is true even if you have a loved one who's already in the nursing home. So the only time it's too late is once they're already on Medicaid, meaning once they've spent down all their assets. We can't get any of that money back for you, but if they're not yet on Medicaid, meaning they're not yet broke, we can still save at least half of whatever they have left. So the more time you give the plan to work, the more ultimately we're going to be able to protect. So we can bypass this spend down amount if we get through the full 5 years. Right? Now, sometimes we don't need the full 5 years in order to protect everything. It's really going to depend on what are the assets. How much money does someone have? If the estate is more modest, oftentimes we can get them qualified for Medicaid well before the 5 year time period, even if we don't make it through that 5 years. All right. So what about long-term care insurance? Well, I am a fan of certain long-term care policies. Again, my original career was a financial advisor. I've gone through more training programs than I can count, specifically on long-term care insurance. So very, very familiar with long-term care insurance. In fact, this is something we spend a lot of our time with many of our clients, helping them decide if long-term care insurance is in their best interest, or if they already have a policy, but maybe the premiums just keep going up and up and up. If there are alternatives we could look at that could accomplish the same thing as the long-term care insurance, but in a way where you're not having to shell out all that money each year. So that the biggest issue with long-term care insurance, the reason why most people don't have this is it's expensive. And I know that's not a secret to any of you. And the older you are when you look into this, the more expensive it's going to be. So let's say you're 60 years old or over and you're married. To get a good long-term care policy, plan on spending at least $5,000. Now that's per year, every year until you either die or need long-term care. So let's say that you buy this policy when you're 60 and you need nursing home care when you're 80. Well, we're paying $5,000 a year, and let's assume that never even goes up, which I think we all know is not going to be the case. But just to keep the math easy, let's say premiums never go up. So $5,000 per year over 20 years, you spend $100,000 on that policy, which I think we'd all agree is a great investment if by spending that money, that allows you to protect everything else you have. So let's say you've got $400,000 total, not counting the house. You spend $100,000 of that on long-term care insurance, which allows you to protect the other $300,000. Well, I think that's a heck of a return on that investment. The thing is, we can accomplish the same thing at a fraction of the overall cost. Now, the one thing I can't guarantee is, if we implement the plan and we don't get through the 5 year look back period, we're still going to be able to protect at least 50%. But depending on what the assets are, the long-term care insurance could have been a better investment. Probably not that likely, especially if you are closer to 60 instead of 80. If the more time we get for the plan to work, the more we're going to be able to protect. And again, legal planning doesn't cost $100,000, not even close. So I am a fan of long-term care insurance, but like I said, if we're comparing apples to apples and what is the cost of providing this protection, legal planning is a much better investment. All right, so your action plan, you have to put a plan in place that addresses the possibility of needing long-term care in the future. Now, I know this is something that none of us ever want to have to need, but you know what? That has absolutely nothing to do with whether or not you will need this care. No one needs nursing home care. And yet they're building nursing homes just about as fast as they can. And I know that's not a surprise. Most of the major building projects that you see if you're riding around town are some sort of long-term care facilities. The doctors can keep us alive a lot longer than they could even 10 years ago, but not necessarily in a way that we can take care of ourselves. And regardless of what you believe, as far as whether you should be able to opt out on your own terms, the reality is that that's not allowed, at least not in Ohio today. And you can't very well expect your family to take care of that for you, or at least I don't think you should. They might wind up in a whole host of problems if they do. So you have to plan for this. And if you do, we can help make sure that you're not going to run the risk of losing everything should you need long-term care. And if you're married, you're not going to leave your spouse destitute, if you need this type of care, as long as you've planned for it ahead of time. All right. So far we've talked about why you want to bypass probate. We've talked about how important it is to make sure your power of attorney is powerful enough. And we've talked a little bit about how Medicaid works and the importance of planning for future long-term care. So I asked you this question at the very beginning. What if you could wave that magic wand and accomplish everything you want to accomplish, while at the same time bypassing all of these issues that no one ever wants to have to deal with? Well, it's not that simple, but it's not overly complicated either. They say that knowledge is power, and I disagree with that to some extent. Knowledge in and of itself doesn't do anything for you. So you could attend every legal presentation that's available, and if you never act on what you're learning, it was just a huge waste of time. So you have to commit to getting this area of your life once and for all taken care of. Again, none of us are promised a tomorrow. So I hope you get, after our time together, that you can legally protect your home, your assets, from the government taking it from long-term care. You make sure you have enough income and assets for the rest of your lifetime. If you're married, the rest of your spouse's lifetime. The importance of having a plan for care, so you're never a burden on your spouse, your family. You don't have to worry about losing everything if you do need this type of care, and how to protect yourself, your spouse, your kids, while at the same time maintaining control. Now, I haven't addressed yet how to prevent conflict and how we protect the inheritance for the kids. It's pretty simple. We can set things up where your kids, once they receive their inheritance, it's set up in a way where they can get their hands on it, but no one else could ever take it away from them. Now, this involves using very specific types of trust provisions, and we don't have time today to go through exactly how these work. All I wanted to do is kind of plant the seed in your mind that we can do this, and it's really not even all that difficult. We just have to be proactive about it. And then as far as how we minimize the odds of the family fighting after you're gone, it's pretty simple. Every estate plan we create, we include something called a no contest clause, which in a nutshell says after you've passed away, or if you're married, after you've both passed away, if any beneficiary files suit in court claiming that they should get more than what you've already decided, they would get a warning first, but if they disregard that warning, they move forward with the lawsuit, they're written out automatically. Well, no one's going to be silly enough to continue with that lawsuit if they know the end result is that they don't get a dime. So that's how we can pretty much guarantee that there's not going to be any major family fighting after the parents have passed away. All right. So I mentioned earlier that you can have us review all of your legal documents. It's not going to cost you a dime. The way you do that is we're offering a no-cost consultation. And if you decide you do want to do any legal work with us, having attended the presentation today, this will save you some money. So if you decide to do what we call a foundation plan, which is the basic documents, the will, power of attorney, the healthcare documents, we'll take $100 off of that plan. And even with the will-based plan, we're not doing that so that ultimately you have to pay us a whole lot more in the long run by going through the probate process. We'll walk you through step by step how to set up each of your assets, everything you own, so that none of that has to go through the probate process. All right. Now, if you decide you want to do what we call a protection plan, whether that's protecting what you have from the nursing home or anything else you're concerned about, that's a plan where we're using it any variety of a type of trust. With that type of plan, having attended the presentation today, we'll take $500 off the normal fee for that. And even if you just want to sit down with us, have us review your current documents, give you our thoughts on how everything is set up, still don't pay us a dime. Now, there is a catch. And the catch is I can't make this free consultation available to everyone. If I'm only sitting down with clients who never pay me a dime, it gets pretty tough to keep the lights on, if you know what I mean. So we make 10 spots available for the no consultation appointments. Normally, our consultation fee, which is a 2-appointment process, normally the cost to do that is $695. We're going to waive that. But again, we can only make that offer available for the first 10 people who raise their hand. So the way you do that is if you open the chat box, type in the word yes, and that locks in your place for one of those 10 free spots. And just to make sure there are no surprises, we have more than 10 people on the call with us today. So if each of you raise your hand, unfortunately, I'm not going to be able to give everyone a free appointment spot. So you want to take advantage of that as soon as you can. Just open the chat box, type in yes, that locks in your spot. All right. So only have a couple of slides left, and then we'll open it up for a Q&A session. And I'll also make a couple of last points, because I know not all of you may want to stick around for the Q&A session. So give me a couple more minutes. I just have a few last things to address. And I don't think I need to go through this slide. Hopefully you all realize that the issues we've been talking about today are pretty darn important. All right, so how does the no-cost consultation process work? Well, the first appointment we schedule for 90 minutes. We call this our vision meeting, simply because the whole appointment is all about what your vision of your future looks like. What are all the things you want to make sure you absolutely can accomplish? What are all the things you never want to have to deal with? So it's really a deep dive into not only what you want to see for your future, but also what the situation is today, including what, if any, legal planning you've done up to this point. And again, we would ask you to bring with you any and all of your current legal documents so that we can review everything for you and let you know how things are set up. So again, the first appointment is all about you, your current situation, what you want your future to look like. So the first appointment will be with one of these three ladies that you see on the screen. Now, none of these ladies are attorneys, and that's by design. Over the years, I've kind of learned, much to my chagrin, that not everyone looks forward to coming in to talk with an attorney. Yeah, I don't get it. Obviously, I'm being a little facetious. I know exactly what that feels like, because again, before I was an attorney, I went through this with my grandmother's situation. And those half a dozen attorneys I sat down with prior to finding the attorney who would help us, it was not a good process. In fact, it was incredibly frustrating. So I know that some of you may have been through something like that previously, or at least the image of what this is going to look like is not a good one. So the first appointment by design is not with an attorney. They're not going to use legal mumbo jumbo. They're not going to talk over your head to purposely confuse you. We don't work that way. And again, the first appointment, you can be comfortable that they're not going to use any legal jargon, because they're not attorneys. And again, this is all about finding out about you and your family. not a lot of legal conversation at that first appointment. Now, after the first appointment, what happens then is you're going to have a clear vision for what you want your future to look like, clear path as far as how you get there. You'll know all the things you do need. We're not going to talk about anything you don't need. So after that first appointment, then my team and I get together, and based on what you've told us you're wanting to accomplish, we're going to put together a proposal, a recommendation, and we share that with you at the second appointment, which again, if you raise your hand, indicate you want one of those 10 free spots, you're not going to pay anything for the first appointment or the second appointment. Second appointment is where you'll sit down with an attorney and we'll review the recommendation for you. And then you're free to make whatever decision you feel is in your best interest, whether that's to work with us or not. Completely up to you. So the second appointment will either be with myself or it'll be with this handsome gentleman here. This is Brennan Russell. He's one of my attorneys. I've got another attorney, but Brennan and I are the only ones who do the second appointment where we review with you the recommendations. Brennan is a heck of a nice guy, very easy to talk with. Neither Brennan or myself are going to use legal mumbo jumbo, talk over your head. And I know Brennan won't do that because that was a really important issue in the interview. If he did, there's no way he would have been hired. Now, Brennan is not a new attorney, but I don't think it's much of a secret which one of us is older, which one of us is younger. By design, Brennan is a couple years younger than I am, well, maybe a couple decades younger than I am. And again, that's so that if I drop over dead at my desk one day, Brennan, being a lot younger than I am, hopefully is still doing fine. And my clients are taken care of. Like I said, I have another attorney as well. And we're currently interviewing for a fourth. So if any of you know a good attorney, send them my way. Be happy to talk to them. All right. So again, if you want one of those free spots, open the chat box, just type in the word yes. That's going to lock in your spot. Now, you'll also notice in the chat box, there's a link you can follow where you can schedule the appointment just from your computer. You don't even have to call my office, talk to anyone in my firm. You can just do it from your computer. Now, don't click on that link just yet, because if you're on your mobile device, on your smartphone, if you click on that link, you're going to leave the presentation. So if you give me just another 2 minutes, then I'll kind of wrap things up. We'll start on the Q&A. So if you're on your desktop or laptop, you can click on the link. You're not going to leave this presentation. But again, just typing in yes locks in your spot. Now, when you click on that link, it's going to take you to a different page. And like I said, you can schedule your initial consultation right from your computer. Now, it's going to ask you whether you want to schedule a virtual appointment where we're using Zoom or something similar where you're not coming into the office, or if you prefer to do things face-to-face, which I personally do. You can come into one of our office locations. We've got offices in Dublin, in Lancaster, which is 30 miles southeast of Columbus. And then we've got an office location in Eastern Ohio in St. Clairsville. But we've got clients every corner of the state, from Toledo to Cleveland, Cincinnati, Marietta, everything in between. And that's been one of the few positives that have come out of this pandemic, is we've all been forced to get a whole lot more comfortable with virtual meetings, whether we wanted to or not. But even prior to the pandemic, it still had a lot of clients who wanted to work with us, even though they didn't live close to one of our office locations. Right? So again, you can set the appointment either so we're meeting virtually, or if you prefer to come in the office, we can make that available to you. We'll just ask for you to wear your mask. We'll be wearing ours. All the common surfaces are disinfected between each appointment. We're doing everything we can to keep everyone safe. That includes you as well as my staff and myself. We don't want anyone getting sick. All right. So we're doing everything we can in that regard. All right. That's all I have as far as the formal presentation. I know I went a little bit over. I apologize, but I feel like this information is incredibly important, so that none of you find yourself having to deal with any of these issues, or your family having to try to figure out how to clean up, one of these big messes, because you didn't get around to planning your affairs. And I know it's incredibly easy just to put this on the back burner. I'm willing to bet that for all of you on the call today, this is not your first presentation you've ever attended, put on by an attorney. My guess is you've been thinking about getting your affairs in order for quite some time. Again, if you never get around to doing it, then chances are your family will be forced to have to figure out how to clean up one of these messes if you don't address this yourself ahead of time. All right. And I don't mean that to sound judgmental. I can just tell you, probably at least 50% of the families we're sitting down with, it's when they're in that crisis scenario because mom or dad just thought they had more time. Well, unfortunately, none of us know when these issues are going to come up, which just means it's that much more important to get these things addressed ahead of time. All right. So I'm going to go ahead and open the chat box now. Now, if you're not interested in sticking around for the Q&A, you're not being rude if you hop off at this point. And not that it mattered, but you're not being rude. If you don't want to stick around for that, certainly you can hop off now. Before you do, let me just, again, thank all of you, each of you, for attending today. Appreciate you spending a part of your day with us. I hope this was a good use of your time. Wish you all the very best. Look forward to continuing this conversation with each of you, regardless whether we do or whether we don't. I wish you all the best of luck. Please stay safe and healthy. So I'm going to go ahead and open the chat box now, and we'll see what questions you folks have for me. And if you haven't yet asked your question and you want to, you still have time to open the chat box, type that in. Now, I see everyone's chat box, so it takes me a little bit to find the questions. First question, looks like this is from Phyllis. I won't use any last names, but I just want you to, if you hear your name, hopefully it'll your ears will pick up a little bit. So Phyllis, your question, does a power of attorney end at death? The answer is yes, it does. So if you name someone else your power of attorney when you pass away, that's terminated along with you. Which means we have to make sure that we've got the plan set up correctly so that we don't have to get the court involved in handling your affairs or winding up your affairs after you're gone. All right, next question. Let's see. I'm only seeing one last question, and it's actually I don't see a name on this one. I'm going to paraphrase it because it's kind of long. It's regarding a family member who has been diagnosed with dementia and whether it's too late for them to sign any legal documents. And more than likely, it probably is not. It's going to depend on whether or not they still have any comprehension of their current situation. The test in Ohio is not overly difficult. Basically, what it comes down to, in order for someone to sign a new power of attorney, because once they sign that, we're going to include all the appropriate language and authorizations in there so that the family member, whomever is named as a decision maker, can legally handle everything and anything else that we might need to do. So really, it only comes down to what are the requirements for them to sign legally a new power of attorney document. And the test is pretty low. The first component of it is they have to have some understanding of what the relationship is between themselves and the person that they're going to name as their decision maker. So if they understand that they're your mother, you're their child, and they understand that they've got 3 other kids, that's the first component. Pretty easy test. The next component is they have to have some sort of understanding of what it is they own. They don't have to tell me down to the penny how much they have, but they basically have to understand the difference between owning $50,000 worth of assets and 500,000. They have to be in at least the right ballpark. And then lastly, they have to have a basic comprehension of what it is they're signing. They understand that by signing this document, they're allowing you to handle any of their affairs, then that's all that's required. And we can legally have them sign a new power of attorney and it'll be perfectly valid. All right, let's see. One last question, follow-up from Phyllis. Do you handle probate? We do. Now, our goal for all of our clients, if they start working with us, before they pass away, we're going to make sure everything is set up to bypass probate. But if you have a family member who, for whatever reason, they weren't able to do the same thing, then yes, we are more than happy to help with the probate process. That's all the questions I'm seeing. Well, one last one, and then I promise that'll be it. It's from Dave. What happens if I move to Florida or West Virginia later? So the answer is any plan that we would put in place here in Ohio is going to work in any other state. Same thing as if you had a plan put in place, let's say in Florida, you move to Ohio. The only exception to that is the healthcare documents. So the healthcare power of attorney and living will, those are state specific, but those are pretty simple, pretty straightforward. In fact, in my firm, we don't even charge for those things because the hospitals use the exact same forms that we use and they don't charge for them. So I don't figure I should charge for them either. Everything else will work from one state to the next. All right. As I promised, that's the last question. I know I've kept you all longer than I said I would. I apologize. I hope that it was worth your time. Again, I look forward to continuing this conversation with each of you. Wish you all the best of luck. Thanks again for joining us today. God bless. Enjoy the rest of your day. Thank you. Bye-bye.